before any money is appropriated for the construction of said main canal and appurtenant structures to connect the Laguna Dam with the Imperial and Coachella Valleys in California, or any construction work is done upon said canal or contracted for, the Secretary of the Interior shall make provision for revenues, by contract or otherwise, adequate in his judgment, to ensure payment of all expenses of construction, operation, and maintenance of said main canal and appurtenant structures in the manner provided in the reclamation law. If during the period of amortization the Secretary of the Interior shall receive revenues in excess of the amount necessary to meet the periodical payments to the United States, as provided in the contract or contracts executed under this act, then, immediately after the settlement of such periodical payments, he shall pay to the state of Arizona 18 3/4% of such excess revenues, and to the state of Nevada 18 3/4% of such excess revenues. Section 5. That the Secretary of the Interior is hereby authorized, under such general regulations as he may prescribe, to contract for the storage of water in said reservoir, and for the delivery thereof at such points on the river and on said canal as may be agreed upon, for irrigation and domestic uses, and generation of electrical energy and delivery at the switchboard to states, municipal corporations, political subdivisions, and private corporations of electrical energy generated at said dam, upon charges that will provide revenue which, in addition to other revenue accruing under the reclamation law and under this act, will in his judgment cover all expenses of operation and maintenance incurred by the United States on account of works constructed under this act, and the payments to the United States under subdivision B of Section 4. Contracts respecting water for irrigation and domestic uses shall be for permanent service, and shall conform to paragraph A of Section 4 of this act. No person shall have, or be entitled to have their use for any purpose of the water stored as aforesaid except by contract made as herein stated. After the repayments to the United States of all money advanced with interest, charges shall be on such basis, and the revenues derived therefrom shall be kept in a separate fund, to be expended within the Colorado River Basin, as may hereafter be prescribed by the Congress. General and uniform regulations shall be prescribed by the said Secretary for the awarding of contracts for the sale and delivery of electrical energy, and for renewals under subdivision B of this section, and in making such contracts the following shall govern. A. No contract for electrical energy or for generation of electrical energy shall be of longer duration than 50 years from the date at which such energy is ready for delivery. Contracts made pursuant to subdivision A of this section shall be made with a view to obtaining reasonable returns, and shall contain provisions whereby at the end of 15 years from the date of their execution, and every 10 years thereafter, there shall be readjustment of the contract, upon the demand of either party thereto, either upward or downward, as to price. As the Secretary of the Interior may find to be justified by competitive conditions at distributing points or competitive centers, and with provisions under which disputes or disagreements as to interpretation or performance of such contracts shall be determined either by arbitration or court proceedings, the Secretary of the Interior being authorized to act for the United States in such readjustments or proceedings. B. The holder of any contract for electrical energy not in default thereunder shall be entitled to a renewal thereof upon such terms and conditions as may be authorized or required under the then existing laws and regulations, unless the property of such holder dependent for its usefulness on a continuation of the contract be purchased or acquired, and such holder be compensated for damages to its property, used and useful in the transmission and distribution of such electrical energy, and not taken, resulting from the termination of the supply. C. Contracts for the use of water, and necessary privileges for the generation and distribution of hydroelectric energy, or for the sale and delivery of electrical energy shall be made with responsible applicants therefor who will pay the price fixed by the said Secretary, with a view to meeting the revenue requirements herein provided for. In case of conflicting applications, if any, such conflicts shall be resolved by the said Secretary, after hearing with due regard to the public interest and in conformity with the policy expressed in the Federal Water Power Act as to conflicting applications for permits and licenses, except that preference to applicants for the use of water and appurtenant works and privileges necessary for the generation and distribution of hydroelectric energy or for delivery at the switchboard of a hydroelectric plant shall be given, first, to a state for the generation or purchase of electric energy for use in the state, and the states of Arizona, California, and Nevada shall be given equal opportunity as such applicants. The rights covered by such preference shall be contracted for by such state within 6 months after notice by the Secretary of the Interior, and to be paid for on the same terms and conditions as may be provided in other similar contracts made by said Secretary, provided, however, that no application of a state or a political subdivision for an allocation of water for power purposes or of electrical energy shall be denied, or another application in conflict therewith be granted on the ground that the bond issue of such state or political subdivision, necessary to enable the applicant to utilize such water and appurtenant works and privileges necessary for the generation and distribution of hydroelectric energy, or the electrical energy applied for, has not been authorized or marketed until after a reasonable time to be determined by the said Secretary, has been given to such applicant to have such bond issue authorized and marketed. D. Any agency receiving a contract for electrical energy equivalent to 100,000 firm horsepower or more may, when deemed feasible by the said Secretary, from engineering and economic considerations, and under general regulations prescribed by him, be required to permit any other agency having contracts hereunder for less than the equivalent of 25,000 firm horsepower, upon application to the Secretary of the Interior made within 60 days from the execution of the contract of the agency the use of whose transmission line is applied for, to participate in the benefits and use of any main transmission line constructed or to be constructed by the former for carrying such energy, not exceeding, however, 1/4 the capacity of such line, upon payment by such other agencies of a reasonable share of the cost of construction, operation, and maintenance thereof. The use is hereby authorized of such public and reserved lands of the United States as may be necessary or convenient for the construction, operation, and maintenance of main transmission lines to transmit said electrical energy. Section 6. That the dam and reservoir provided for by Section 1 hereof shall be used, first, for river regulation, improvement of navigation, and flood control; second, for irrigation and domestic uses and satisfaction of present perfected rights in pursuance of Article 8 of said Colorado River Compact, and third, for power. The title to said dam, reservoir, plant, and incidental works shall forever remain in the United States, and the United States shall, until otherwise provided by Congress, control, manage, and operate the same, except as herein otherwise provided, however, that the Secretary of the Interior may, in his discretion, enter into contracts of lease of a unit or units of any government-built plant, with right to generate electrical energy, or, alternatively, to enter into contracts of lease for the use of water for the generation of electrical energy as herein provided, in either of which events the provisions of Section 5 of this Act relating to revenue, term, renewals, determination of conflicting applications, and joint use of transmission lines under contracts for the sale of electrical energy, shall apply. The Secretary of the Interior shall prescribe and enforce rules and regulations conforming with the requirements of the Federal Water Power Act, so far as applicable respecting maintenance of works and condition of repair adequate for their efficient operation, maintenance of a system of accounting, control of rates and service, in the absence of state regulation or interstate agreement valuation for rate-making purposes, transfers of contracts extending beyond the lease period, expropriation of excessive profits, recapture and / or emergency use by the United States of property of lessees, and penalties for enforcing regulations made under this Act, of penalizing failure to comply with such regulations or with the provisions of this Act. He shall also conform with other provisions of the Federal Water Power Act and of the rules and regulations of the Federal Power Commission, which have been devised or which may be hereafter devised for the protection of the investor and consumer. The Federal Power Commission is hereby directed not to issue or approve any permits or licenses under said Federal Water Power Act upon or affecting the Colorado River or any of its tributaries except the Gila River in the states of Colorado, Wyoming, Utah, New Mexico, Nevada, Arizona, and California until this act shall become effective, as provided in Section 4 herein.